And greetings, everybody. Keith coming at you, introducing Wyrd Wyzard. Greetings and welcome for all you first-time comers. As you see on the panel there, you got introducing Wyrd Wyzard. See our other channels in details section below. If they're not listed there for some reason on Wyrd Wyzard itself, and you're watching from El Perro or Keith Little, they should be in the details section. And just check out those 5 channels at the bottom. Those are the 5 main channels we will be working with as far as my research. And this particular channel, Wyrd Wyzard, we're going to get into the construction of words, which is philology, and the etymology of words, which is the origin, and of course the practice of adoption and conversion for the various different uses in various different forums. So tonight we're going to talk about Ejusdem Generis. Ejusdem Generis. And let's take a look at it. Oops, where are we at here? Okay. And this is just a regular Google search here, and we're going to go over a couple others before we get done for the night. And what we're looking at here is just the normal pull-up from Google. Ejusdem Generis is a Latin phrase that means of the same kind. This goes to like when you're a little kid and they have that panel with the square and the star and the triangle and the circle and the half moon and blah, 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 and the different shaped pegs. Only certain shapes work. The same with language. There are certain phrases of the same kind. And is a legal principle used to interpret laws and contracts. It states that when a general term follows a list of specific terms, the general term is limited to things that are similar to the specific terms. This is in the English language, of course, in reverse as well. If you've got a general term that is followed by a list of specific terms, those specific terms that follow would be, of course, relative to the general term. For example, if a law mentions cars, trucks, and motorcycles, the term vehicles would likely be interpreted to mean only motorized vehicles and not airplanes or boats. Okay? Ejusdem Generis is an example of the Nomenclator Associis principle, which is general principle of construction. That's why we're going to be talking about philology, the construction of words according to their origins, which would be relative to those cultures and their intended use, and not specifically an adoption and conversion. It's been used by English courts since the 16th century and New York courts since the post-revolutionary period. Ejusdem Generis is a common drafting technique that helps legislators avoid having to spell out every contingency in advance. However, some studies have found that a significant number of professional drafters don't rely on Ejusdem Generis in their work. That's part of the particular problem that we have today, folks, with comprehending each other, is people don't want to stick to what's intended. This is why I talk about concise English. Concise English was brought about in the 1970s as a matter of bringing commonality to the colloquial uses of this English language. So let's take a look at the next one. The next one is Cornell Law, LII Westlaw, Cornell Legal Information Institute. And it says Ejusdem Generis. Ejusdem Generis, Ejusdem Generis, is a Latin phrase that means of the same kind. The statutory and constitutional construction principle of Ejusdem Generis states that where general words or phrases follow a number of specific words or phrases, the general words are specifically construed as limited and apply only to persons or things of the same kind or class as those expressly mentioned. So I have a sparrow, an eagle, a falcon, and a frog. Although they are all animals, Ejusdem Generis says the frog doesn't match. For example, if a law refers to automobiles, trucks, tractors, motorcycles, and other powered vehicles, a court might use Ejusdem Generis to hold that such vehicles would not include airplanes because the list included only land-based transportation. Ejusdem Generis is an interpretive guide for a contract under New York law. The rule is used only to help determine whether there is intent. This is why we need to understand the philology, the original construction, and the intent according to that culture, and the change that it goes through once being adopted and converted. Otherwise, we might find ourselves speaking a double mind. If intent is found, Ejusdem Generis does not subvert intent. Very simple. Now the next one, let's refresh. There we go. And this one here is from Illinois, evidently. You see the shape of Illinois here. It says Appellate Lawyers Association. And they speak of Ejusdem Generis and statutory construction. And the part we're interested in is this. And it says, actually it's this here, we're going to read this. Similarly, when the Human Rights Act prohibited discrimination in a public place of accommodation, and that term was statutorily defined to include a long list of examples, such as restaurants, hotels, and public swimming pools, as well as other places of public accommodation and amusement. That residual clause was held not to include an educational program at a university. Okay, this is Board of Trustees of Southern Illinois University versus Department of Human Rights, 1994. And it says the examples listed in the Act are fundamentally different from institutions of higher education, which administer educational programs. The cited list of establishments are examples of facilities for overnight accommodations, entertainment, recreation, transportation. Thus, what was anticipated by the General Assembly is a restaurant or pub or bookstore. What was not anticipated is an academic program of a higher education institution. The Human Rights Act was subsequently amended to expressly include undergraduate and postgraduate schools as far as public place of accommodation. Now they fit the Ejusdem Generis because they changed the intent by clarifying that it does include that. The doctrine accommodates a common drafting technique designed to save the legislator from spelling out in advance every contingency in which the statute could apply. That's citing 2A N. Singer and J. Singer Sutherland on statutory construction. And it is particularly appropriate because a drafter may not be able to spell out every contingency in advance, either because some contingencies are unforeseen or because spelling out each contingency would have negative consequences. For example, if the legislator is prohibiting something, spelling out each contingency might create easy ways around the definition, and thereby provide a roadmap for evasion. Citing the Singer Treatise, the Supreme Court explained that the Ejusdem Generis doctrine is justified on the ground that if the general words were given their full and ordinary meaning, The specific words would be superfluous, as encompassed by the general terms. But if the legislator had full and ordinary, had it meant the general words to have their unrestricted sense, it would not have used the specific words. In other words, like most canons of construction, in short, the doctrine reflects a judicial effort to recognize the limitations of language and the challenges inherent in drafting. This, folks, is why I insist that the only true thing that needs to be done is the correction of the record. There is something that just doesn't fit. It's inconsistent, and when you try to rectify it, it becomes an impossibility. Unless, of course, you do qualify in a certain manner and can fulfill those things. But again, it goes down to the language. Does it fit? And if it fits, it has to fit by intent. With that, we've come to the end, and I thank everybody for joining us for this short video. Be prepared for more as the next time we talk about the Iowa Code and the English language and what they say about it. Thank you again for showing up and supporting. Hit that like, share, and subscribe button, and be blessed.